Welcome to the debate. Today, we plunge into one of the most intellectually compelling and, frankly, historically contentious corners of constitutional law, the Ninth Amendment. This single sentence, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, it potentially holds the key to understanding rights that fall outside the explicit text.
And that key text, it was really created to resolve a critical tension right there at the founding, wasn't it?
That's right. That tension being the Federalist fear, championed by figures like Alexander Hamilton, that listing specific rights in a Bill of Rights would dangerously imply the surrender or the denial of rights not included.
Yeah, the disparagement idea.
Exactly. And this fear was pitted against the essential anti-federalist demand for a clear Bill of Rights in the first place. So the Ninth Amendment was kind of the compromise intended to bridge that gap.
Precisely. And the core question that, it still fractures constitutional interpretation today is this. Does the Ninth Amendment establish and protect substantive, unenumerated individual rights that courts must enforce? That's what some scholars call the individual natural rights model.
Right.
Or is it fundamentally limited? Is it just a procedural rule of construction preventing only that specific textual implication that non-enumerated rights are lost, but without providing any independent power?
Okay, so I will be arguing for the Ninth Amendment as a genuine substantive guarantee of these unenumerated individual liberty rights. And I think to honor the text, the judiciary must actively ensure these rights retained by the people are not, in fact, denied or disparaged by the government.
And I'll be arguing the other side, that the Ninth Amendment functions primarily as a rule of construction, a vital safeguard, yes, but a limited one against that negative inference. When I say rule of construction, I mean it's a guide for interpreting the Constitution, preventing a specific kind of textual error, but it doesn't independently define or create some substantive roster of rights for judges to enforce.
Okay, let's lay out the positions then. My position is, it's pretty straightforward. The Ninth Amendment means exactly what its text appears to say. The rights retained by the people are unenumerated individual natural liberty rights, and they require constitutional protection. And we have, I think, extremely strong historical evidence supporting this substantive meaning. Randy Barnett's work, for instance, highlights James Madison's own handwritten notes referring to natural rights retained as speech. Even more compelling, perhaps, is Roger Sherman's draft of a proposed amendment. It explicitly linked these terms, listing examples of natural rights which are retained by them when they enter into society. Things like, rights of conscience and the right to acquire property and pursue happiness and safety. This evidence, I think, establishes the founding-era meaning of the rights being retained.
Okay.
And that historical meaning, it compels a legal effect. The amendment, therefore, is fundamentally inconsistent with any interpretation that gives sort of enhanced protection only to the rights that happen to be listed. Take the famous footnote 4 approach from Carelling Products. That created a tiered system giving specific enumerated prohibitions enhanced judicial scrutiny. That very act, in my view, disparages the unenumerated rights by leaving them subject to, potentially arbitrary legislative whim.
So how do you enforce it then?
Right. To fix this, I propose the judiciary must adopt a rebuttable presumption of liberty. This would require legislatures to affirmatively justify restrictions on liberty as reasonable and non-arbitrary means of serving the common good. Without this kind of standard, the amendment is, it risks becoming meaningless.
That's certainly a powerful framework. But I come at the historical context from maybe a slightly different angle. My claim is that the Ninth Amendment's primary and frankly intended function is solely to prevent that negative inference we talked about. It doesn't independently create or define a list of substantive rights for judicial enforcement. Look at Madison himself. He stated that the objection that enumeration would disparage those rights which were not placed in that enumeration. He called that one of the most plausible arguments against having a Bill of Rights at all. The Ninth Amendment, he suggested, was intended merely to guard against that specific concern. Think of it as a shield against the legal implication, maybe not an independent sword against all legislation.
Okay.
And this reading, it has strong support, both scholarly and judicial. Justice Joseph Story, for instance, characterized the clause as preventing the perverse or ingenious misapplication of the well-known maxim that an affirmation in particular cases implies a negation in all others. Basically, don't misuse the list.
Right, the expressio unios maxim.
Exactly. And crucially, the text doesn't actually affirm the existence or the content of these retained rights. Louis Michael Seidman makes I think, a compelling argument that Congress repeatedly refused to adopt the explicit natural rights language that was proposed by various states and even by Madison and Sherman in earlier drafts. This suggests a deliberate political choice, perhaps to leave the content of those rights unresolved for the future. For us, the living, as he puts it.
A choice to punt, essentially.
You could say that. And the Supreme Court, for the most part, think of Richmond newspapers, for example, has treated the Ninth Amendment exactly as I propose, as a constitutional saving clause, maybe, not a freestanding, enforceable guarantee of specific rights.
Okay, let's definitely turn to that historical evidence, because this really is the crux of our disagreement here. You focus on what was rejected, but I want to focus on the accepted meaning of the words themselves, the words that were adopted, the specific content of Sherman's draft listing those individual natural rights like acquiring property and pursuing happiness, terms, as I said, copied directly from George Mason's Virginia Declaration of Rights. That shows the canonical public understanding of rights retained by the people at that time. The words chosen carried substantive weight, whether or not the founders listed every single one explicitly. That public meaning, I argue, compels a substantive reading of the text that was adopted.
I absolutely grant that your reliance on Madison's notes and Sherman's draft gives weight to the historical meaning of the phrase retained rights. But we have to pivot from the historical meaning to the political reality of what Congress ultimately adopted. It isn't just that Sherman's draft wasn't adopted, it's that the House committee actively removed Madison's initial language that praised the just importance of unenumerated rights. And furthermore, Congress defeated 5 separate proposals that would have expressly protected natural rights. That pattern, to me, demonstrates an intentional political choice, a choice to limit open-ended judicial authority and avoid the very speculative theory that figures like John Vining complained about at the time. If the framers intended to define and entrench judicially enforceable natural rights, they certainly had multiple chances to do so explicitly, and they refused. They opted instead for the minimalist, structurally focused language we actually have.
But see, if the amendment only serves to state that enumerated rights don't deny others, it's rendered, well, utterly ornamental. It's what Barnett calls a mere triviality. It completely fails to secure the retained rights from being denied or disparaged altogether by legislative action. I mean, if retained rights can just be legislated away arbitrarily, what is the point of even mentioning them in the Constitution?
The mandate to protect liberty requires the judiciary to prevent arbitrary restrictions. And that's why implementing something like the presumption of liberty, shifting the burden onto the government, is really the only way to give the Ninth Amendment any actual teeth. Okay, but let's follow that thought. If we embrace your presumption of liberty, doesn't that inevitably require judges to define reasonable and arbitrary on a case-by-case basis? Doesn't that essentially make them, platonic guardians deciding which legislative restrictions are worthy and which aren't? That's the exact kind of subjective authority Justice Scalia warned against, warning about judges imposing their own subjective lists against laws duly enacted by the people.
But the alternative is?
Well, the alternative is recognizing the limited scope. And look, the courts have historically shied away from using the Ninth Amendment as an independent, freestanding source of rights precisely because of this undefined scope. Take Griswold v. Connecticut, a landmark case, right? Well, Justice Goldberg's concurrence did cite the Ninth Amendment. The majority opinion grounded the right to marital privacy in the penumbras, these shadows, sort of, created by the synergy of other explicit amendments, the First, Third, Fourth, and Fifth. They preferred the safer, more textually connected ground of penumbras. That seems to confirm the judiciary's institutional preference to avoid using the Ninth Amendment as the primary source of substantive rights.
But doesn't that very avoidance, that reaching for penumbras, actually confirm that they believe unenumerated fundamental rights do exist and require protection, even if they prefer to use maybe a more palatable vehicle than the Ninth Amendment alone? Relying only on those penumbras and avoiding the Ninth Amendment proper, I'd argue simply confirms the very disparagement the amendment was meant to prevent.
Hmm.
And moreover, a purely passive rule of construction reading can undermine the text's purpose entirely. Look at the 1947 case, United Public Workers v. Mitchell. The court rejected a Ninth and 10th Amendment challenge to the Hatch Act, basically arguing that if a granted federal power is found, while the objection that it invades reserved rights must just fail. That perspective seems to deny the Ninth Amendment any power whatsoever to protect retained rights against granted federal power. It makes it purely an empty statement.
But you could argue that interpretation aligns perfectly with the text's role as a structural check, working alongside the 10th Amendment. It functions as a guard against misconstruction of the Bill of Rights, preventing the Bill of Rights itself from being read to imply that the federal government possesses undelegated power it wasn't otherwise given.
Okay, but even if we explore that structural check further, the result still seems to require judicial enforcement. Consider the federalism model proposed by Kurt Lash. He argues the Ninth Amendment originally preserved the right of the states and localities to self-government, limiting federal power, especially under the Necessary and Proper Clause. Even Lash's model gives the provision judicial effect by requiring courts to constrain federal power through narrow construction. That is still a substantive judicial action, which goes far beyond a purely passive rule of inference, wouldn't you say?
Well, I'd argue that Lash's evidence, while very credible regarding original federalism, actually weakens your core position. If the primary function was preserving local self-government against federal overreach, that seems to undermine the modern focus on the Ninth Amendment as primarily protecting individual rights that can be applied against state legislation via the 14th Amendment.
That's a fair point on the application against states.
Right, the structural function remains key. It's about limiting the scope of federal authority. And that aligns perfectly with Madison's stated intent to address the specific concern that enumeration would somehow enlarge federal authority by implication.
So, to summarize my view, the original public meaning, which I think is supported by foundational documents and, importantly, foundational drafts, clearly ties the retained rights to unenumerated individual natural liberties. To honor the text and avoid making it just a historical footnote without any real effect, the judiciary must actively safeguard these retained liberties. And the mechanism for that is a rule of constitutional construction that mandates a presumption of liberty against arbitrary government action.
And my summary, the history, particularly the legislative history of what was debated and rejected, demonstrates that the framers made a conscious political choice to sidestep defining or enforcing a specific list of natural rights in the Ninth Amendment. It is a carefully limited safeguard, a rule of construction designed primarily to prevent the Bill of Rights from being misinterpreted to imply that the federal government possesses undelegated power. Its role isn't to identify rights, but perhaps to keep the question open. Deciding the specific content of fundamental rights, therefore, is a responsibility that remains with us, the living, rather than relying on a text designed merely to prevent a negative inference.
The fact that we still grapple with this, that we resort to finding penumbras in existing texts, or asserting a general presumption of liberty, I think that just demonstrates how critical and how persistently unresolved the meaning and the legal effect of the Ninth Amendment remains in modern constitutional law.
And maybe that ongoing complexity is the text's genius in a way. It serves its intended purpose, perhaps, of refusing to close the door entirely on the idea of rights without presuming to define those rights for every single future generation.